And thank you to everyone for joining us on Facebook, on the Zoom, and then anybody who watches this after the fact. We're here today to talk about chronic Medicaid. That's Medicaid that pays or helps pay for a nursing home stay long-term. I'm going to start with some disclaimers. This is all New York based. So everything that I'm going to talk about today will not apply 100% in a different state. It may not apply at all in a different state. And so this is very New York centric. It is also not meant to be legal advice. So please go get some personalized advice if you're worried about nursing home Medicaid in the future, or certainly if you have a loved one or yourself are in need of Medicaid to pay for a nursing home now, you want to make sure you're getting personalized advice. So please don't take this as legal advice. We're just trying to educate you so you can be an informed consumer. Today, we're going to talk about this program of community Medicaid, chronic Medicaid. See, I just actually proved my own point right there. I said community Medicaid. And that has been the big conversation the past few years since April of 2020. There have been these threatened look backs and changes in assessments and all of these potential changes, but they've all been to the community Medicaid program, to the home care program. And so what we're going to talk about today is the tried and true chronic institutional Medicaid program that has not changed, that we don't see any potential changes, nothing coming down the line. And so it hasn't really gotten a lot of attention because we've been so worried about these possible changes that we haven't really re-educated people on this same program that's been around for a very long time. So when does it become necessary to have chronic Medicaid or nursing home or institutional Medicaid? So I'm going to give you a scenario just so you understand how this generally comes about. Often somebody will have a health incident at home, either an incident like a stroke or a heart attack, or perhaps a fall and they break something. They're brought to the hospital. They stay in the hospital for at least 2 nights. They then have a Medicare, what we call qualifying stay, which has them go to a rehab facility. And most rehab facilities are rehab and nursing. So they have long-term and short-term. They go to that rehab facility as a Medicare covered patient. Medicare pays for their rehabilitation days. There is up to 100 days of rehabilitation. Some people get cut off earlier than that if there's not a belief that they're benefiting at all from that rehabilitation. Days 1 through 20 are fully covered by Medicare, and days 21 through 100, if you receive all 100, have a copay. That copay, I always have to look at the number, is $194.50 per day. So every facility across the country has a copay for Medicare of $194.50 a day for those days 21 through 100. Now, many people have a Medigap supplement or certain Medicare Advantage plans that pay for some or all of those copay days. So some people may get to the end of those 100 days and they still haven't seen a bill. Whereas others who don't have that higher level of coverage may have a very large bill by the end of that 100 days, because from day 21 through 100, they were being billed at almost $195 a day. And so the question as to when chronic Medicaid will come in will either be at day 21, when there's no other payer source and someone is considered eligible for Medicaid, and Medicaid can start picking up that copayment. Or it might be after the 100 days when somebody is now no longer a rehabilitation patient, needs to stay long-term in that facility, and they become a nursing home resident and need assistance through the Medicaid program. So that's the time period we're talking about, when Medicare has stopped paying and now it has become long-term. There's also a scenario in which somebody could be in their home and just becomes too difficult to stay at home and they need to go to a facility, in which case they may go in and right off the bat need to have Medicaid because they don't have Medicare paying. That has some logistical issues with getting accepted to a facility without a payer source, but it has been done and it can be done. So now we're going to talk about how you become eligible. So now we've gotten through these Medicare days, we need to stay here full time. What makes us eligible for these services? So first of all, in order to apply for chronic institutional Medicaid, assets, countable assets need to be under $16,800 for a single person. So what this means is that your bank accounts, and if you have cash value in a life insurance, this all has to accumulate to less than $16,800. Excluded from that are tax deferred retirement accounts. For example, so say you have an IRA, a 403B, a 401k, these or teachers who have a TDA through the teachers system, that is not counted as an asset. That is a stream of income. I'm going to talk about income separately, but that doesn't count as an asset. So take someone who has a checking account with $10,000 in it and a retirement account with $300,000 in it. That person can be eligible for nursing home Medicaid. And again, we're going to deal with the income separately, but that is an eligible person. That account does not go towards their countable assets. Other exempt assets, which are important to know, is if you have a prepaid burial contract that is irrevocable, and that you have a contract and you've paid into the funeral home. So let's say somebody comes to us and says, I have $50,000. I need to be down to 16.8. How do I get there? There are certain things you can spend money on right away. You can get that prepaid funeral. You can also, if you don't want to prepay into a funeral fund with a funeral home, you can have a burial fund, which I think is about $1,500 if I remember properly, that can be kept on the side as a separate account towards your burial. You can have a life insurance policy with a cash value of $1,500 or less, again, with the idea being that that's going to pay for your funeral. You can, if you are a Holocaust survivor and you have reparation payments, so we have some individuals who receive payments and they were segregated into a different account and they may have accumulated over the years, but we can show that that entire account came from reparations, then those assets are not counted in this calculation. And those are all things that we make sure are not counted. Then if we're trying to make exempt transfers to get someone under the limit, we can give assets to a disabled child. We can give assets to to a trust for the benefit of any disabled person who's under 65 years old. So if somebody has a niece who's disabled, who is under 65, they can create a trust for that individual. And if created properly, transfer assets into that trust without any negative treatment to either person. The transfer to the disabled child, it has to be the individual who's applying for Medicaid. It has to be their child. Or I'm looking at the others, and to a spouse, most importantly, to a spouse. So if one spouse has if the spouse has everything joint and they've got $200,000 in their name, if we shift that money to the spouse who does not need the Medicaid, the other spouse can go on Medicaid. And we have what's called spousal refusal in New York, where one spouse can have the assets and the other spouse can receive the care through Medicaid. Now let's talk about the house specifically. So now let's say somebody came in, they have a house, they have $40,000 in the bank, and they have a $200,000 retirement account, right? So I said the retirement account doesn't count. With their $40,000, they spend down to the 16.8 by maybe prepaying for their funeral and putting it into that fund that I talked about, or transferring to one of these individuals, a spouse, a disabled child, or a trust for the benefit of any disabled person under 65. And then we have to deal with the fact that they have a primary residence. Now, if they are married and their spouse is living in that home, then even though they are leaving the home to be a long-term resident in a nursing facility, that home is exempt for eligibility purposes because the spouse is living in it. If they similarly have a disabled child or a minor child who's living in the house, it is also an exempt asset. if they have a sibling or who has, I'm actually going to go into that separately. So that's who can live in the home and the home's exempt. But what if you want to transfer the home because now I'm a single person, I don't have a spouse living in the home, I want to make a transfer of that home so that it's not part of my assets so that I can receive Medicaid. There are certain persons that I can transfer the property to, and there will not be a penalty. That could be a caretaker child, which is a child that has lived with me for 2 years or more immediately before I go into the nursing home. So the assumption is that they were caring for me, and that's why I was not needing services sooner. You can transfer to a sibling who has an equity interest in the home, who owns the home with you, to a child who's blind, disabled, or under 21 years old, and obviously to a spouse, because you could transfer anything to a spouse. These are all transfers of a home that you can make, and they're not going to come back and say anything about it. I want to explain why we make these transfers to these individuals. So if I need to transfer the home to anyone other than those individuals, we have what's called the 5-year look back. You may have heard of it. The 5-year look back says if you gave anything away in the 5 years immediately before you need a nursing home and you're asking Medicaid to help pay for that nursing home, you will receive a penalty. So for every increment of this divisor that you give away, there's a 1-month penalty. So when someone says to me, what's the penalty? Well, the penalty is going to equal what 1 month privately paying in that facility is. So a 1-month penalty will not be the same for every person because facilities have different rates. So on Long Island, for every $14,012, and this number will change every year, but for 2022, it's $14,012. Every time you transfer that amount of money, it's a 1-month penalty if it's within the 5 years. And in New York City, the 5 boroughs, it's $13,415. So let's use 14,000 as our round number for easy math purposes. If over the 5 years before I need a nursing home, I gave away $28,000, and that could be adding up multiple gifts that I gave away or transferring one asset worth $28,000, that is going to be a 2-month penalty. So certainly if I have a home that's worth $400,000 or more, the penalty would be enormous, because when you divide that number, say the house is worth $500,000 and I divide that by the 14,000, that would be a very long penalty. So that's why people are worried about this 5-year look back, and they're looking to either spend down assets, have exempt assets, or transfer assets to an exempt person, unless they do advanced planning. And the last thing I'm going to talk about today will be what advanced planning you can do in order to save assets in case this is the care that is needed. So that's what the 5-year look back is. What did you give away? A lot of people get confused and they say, well, I wasn't eligible 3 years ago, and that's within the 5-year look back. So, I had too much money. It doesn't matter. You could have as much money as you need during those 5 years, as long as you're eligible on the date that you're looking to apply and you didn't make these transfers. So there are some people who might have started that 5 years with $1 million, but they went on trips and they spent the money on themselves, or they paid for home care aides or whatever it may be. And now at the end of this 5 years, the money is out. That's okay, as long as that money wasn't given away. If money is given away, there is a legal presumption that it was given away for the purposes of qualifying for Medicaid. So if I gave $28,000, say I have, I'll give a perfect example. This happens all the time. People come in and they say, I didn't give anything except the $15,000. What they're referring to is that the federal government says that you can give, this year it's actually $16,000, but in the past it's been 15, it's been 13, it's been 10. You can give away $16,000 and there's no gift tax. Now, for someone who's worried about Medicaid, that's likely a red herring, because you can only accrue a gift tax if you give away more than your lifetime exemption, which right now is $12 million. So most people who are going on Medicaid aren't worrying about giving away more than $12 million. But they say, well, I gave each of my children $15,000 a year. Well, the presumption is that for each of those $15,000, it's a little more than a 1 month penalty. And if you did it to 2 children over 5 years, that's more than 10-month penalty for giving those gifts that somebody just thought could be done because the IRS said so. But Medicaid doesn't care what the IRS says. So what I often say to people as well, we might be able to argue that that was not given for the purpose of qualifying for Medicaid. We can rebut the legal presumption that that is why it was done. And there are a lot of factors that go into whether or not you could win that argument. And that's usually done at a hearing, a fair hearing, after the Medicaid application is given this penalty. But there are different factors that go into it. How sick was the person when they gave the gifts? Did it render them insolvent? Did they have no money left when it was over? Is this a pattern of gifting that had been done for a long time? Did they consult with an elder law attorney about transferring assets? And all these different things go into whether or not you can rebut that presumption. So what we try to do is plan in advance to transfer things in advance of that 5 years, if that's what the goal is. And then again, to see what exempt assets and exempt transfers are available. The other concept that I want to discuss specifically with the home, because we talked about it can be exempt if certain people are living in it. You can transfer it and it's exempt from any penalty if you transfer it to certain people. Or there's something called an intent to return home. This is a term of art. This is a legal term in the Medicaid world that means that that person is going into a nursing home. They're asking Medicaid to pay long-term, but they still plan to go back home. And what that does is it gives a grace period where someone can receive the care in the facility, but hold the home, keep it exempt for a period of time until they can go back into their home and live there again. If they go back into their home, any potential lien against that home would be extinguished because they did in fact return to their home. But if after 6 months or a year, and it's a little depending on the county how it's applied, if you stay in your home, if you stay in the facility and you don't go back to your home, the home now becomes an asset that renders you ineligible for Medicaid, and it has to usually be sold. There could be a lien on it, and there's work that has to be done. But there is that grace period if you believe that you are going to try and keep rehabbing and return home, where the home can be held on the side for you. And it also changes the amount of income. It makes it so you can keep a little more of your income than you would otherwise be able to keep. So let's talk about income. Great time to talk about it. Actually, before we talk about income, I want to talk about what happens if, let's say, somebody does no planning. And to make it very simple, they have $300,000 in cash and they don't have any retirement accounts. They rent their apartment, so we don't have to worry about a house. They just have $300,000 in cash. Well, that person may come to us, or their family member may come to us and say, oh my gosh, what do I do? My mom needs a nursing home. I don't want her to lose all of her $300,000 that she worked so hard for. Is there any way we can save any of it? She didn't plan 5 years in advance. And the answer is yes. We can save part of her assets. And this is how. I'm going to share my screen just to show the example. This is the coloring is a little off, so I apologize, but I think the point is well made. Okay, so what we have here is an example of a gift and loan. And this is basically how we can make it so that someone who has $300,000 does not lose the ability to receive some assistance from Medicaid. So for example, the Medicaid applicant, so I'm going to circle it here on the left, the Medicaid applicant has their $300,000. We leave $16,800 in their name because that's what they're allowed to have. we prepay for their funeral, we make any of those other exempt transfers we can make. And let's say now the excess is 200,000, right? And I'm only using those numbers to make it easy, round numbers. They take their 200,000 that they're over and they give it away. That's what this arrow is. And when they give it away, part of it is a loan and part of it is a gift. The portion that's a gift to, let's say, a family member, I'll use mother, daughter, just to make it simple. Daughter gets a gift. That portion is. Remember, I said, if you transfer assets within 5 years, for every 14,000 or so that you transferred, there's a penalty. So let's say, and I'm going to just say half, just for the sake of my argument. Let's say half of that was a gift. So about 100,000, right? So we've got, let's see, let me do some quick math. Maybe we got, let's say, a 5 or 6 month penalty, right? So how do we pay for the penalty period? Well, this loan is pursuant to a valid promissory note. And that promissory note, the daughter promises to pay mom monthly loan payments. And when those monthly payments plus mom's income, her Social Security, her pension, plus those loan payments equals the private pay rate for the facility during the Medicaid penalty. So what we've been able to do here is, all the way on the right, protect a large portion of the asset as a gift, and then use the balance of it to pay through the penalty period that we've created and to pay that private rate at the facility. Now you can see I can't give you exact numbers here because, one, I don't know what the private pay rate at that facility is. And two, I don't know what mom's other income is. So her Social Security, does she have a pension? Does she have distributions from a retirement account? Someone like in my example who maybe only has Social Security, no other pension, no other distributions, those loan payments, that loan is going to have to be very big because that's going to have to pay the bulk of the rate at the facility. Whereas if I have someone who has a lot of Social Security, a big pension, a big required minimum distribution from their retirement account, the loan can be much smaller because I have a much smaller shortfall to make up that private pay rate at the facility. As many of you probably know, Berner Law Group was started by Nancy Berner, my mother, and I have always heard her describe this to people. And her next thing she says is, don't try this at home. So I would say if you're someone who falls in the category of having these excess assets and trying to protect them, you need a lawyer. There are a lot of legal issues here that have to be done, but this is supposed to kind of explain the concept to you of that gift and loan portion. Okay, so that's what we do when somebody gets to the point where they didn't protect any assets and it's time and they need a facility, and what do we do? Now, what happens with income? Because I didn't talk about income yet. So basically, your income goes to the facility. Your income will go to the facility and Medicaid pays the balance. So let me give you some numbers so you have an idea. A private pay for a nursing home, Long Island, the 5 boroughs, is generally, there's obviously higher and lower, I'll say between $15,000 and $20,000 per month. That's private pay. So Medicaid pays a much lower rate. Let's say if a facility is $18,000 a month, maybe Medicaid would pay $9,000 or $10,000 a month, just as an idea. So if you have Social Security and then you have a distribution from that retirement account, maybe your income is $3,000 per month, you pay your $3,000, $50 goes into an account for you to use at the facility for whatever you might need it for, hair, nails, etc. And then the balance of your bill is paid by Medicaid. So it's never, unless someone has $0 of income, or if they have a spouse, which I'll talk about, it's not usually that Medicaid's paying the full. And that's why I always describe it as to have Medicaid help pay for your nursing facility, because you give your income, Medicaid pays the balance. Now, if you have no income, then you have no contribution towards the cost of your care. Similarly, if you have a spouse at home and your spouse at home has a small amount of income or no income, we can shift income to the spouse at home. So this year's number is $3,435. So let's say spouse in the nursing home has all the income. They have a required minimum distribution, they have Social Security, they have a pension. And the spouse who's at home maybe didn't work or didn't pay into the system, only has $800 a month in Social Security. The spouse at home keeps their $800 and they get part of their spouse in the facilities income so that they get a total of $3,435 per month. So the spouse at home has to live on the $3,435 and the balance of the income is going to the facility. Now, if the spouse at home has more than $3,435, let's say the spouse at home has $5,000 a month in income, they don't get any of the income that belongs to the spouse who's in the facility. That would all go to the facility. So there's a potential, though, that you could have income that goes higher than the Medicaid rate. So let's say Medicaid charges that facility $9,000 per month for the cost of care. Well, if your income, because you were, I have retired, firefighters, police officers with very high pensions, maybe they have tax deferred retirement, you add in all their income, maybe they have $11,000 a month in income. Well, if that's the case, then you can't end up having Medicaid pay, because think about it. If you give your income and Medicaid pays the balance, there's no balance for Medicaid to pay. So in those cases, we still like to do planning and we still like people to be eligible, because we can actually make it so that you pay your income, and that facility, if you get denied Medicaid because your income is too high, because it's higher than that Medicaid rate, that facility has to allow you to privately pay the Medicaid rate. So that individual never pays more than their income. They can always keep their other assets or they'll be protected. And so that could be a big difference between someone paying $20,000 a month or $10,000 a month. I'm going to stop because I think there were some questions that came in. So Liz, maybe we'll go through some questions and then we can see where we are.
The first question up, how are continued contributions to your church considered in the look back period?
That's interesting. So technically that falls on the category of a gift that would create a penalty period. Now that being said, if you have given those gifts to your church for 10 years, more than, for a long, long time, and they are not something that make it so you have no money left over, you have a very good argument to argue that this is a gift that should be excluded from the calculations because it is a customary gifting. It's something you've always done and it falls in that category. So any gifts, so a contribution to your church counts as a gift. Any gift has that presumption that it creates a penalty, but you would have a good argument likely against that so that you weren't penalized.
Thank you. Next question. What is considered income for Medicaid?
So for long-term care Medicaid, for aged, meaning over 65, blind or disabled persons, and certainly for care in a nursing home, every piece of income is income. So Social Security, pension, required minimum distributions, if you've put assets into a trust and there is income payable to you from that trust, for interest and dividends, that's considered income. If you have a rental property that you've protected in a trust and you get rental income from that, that's considered income. If you have certainly wages and salary, although that's a lot less likely with our clients who are now in nursing facilities. I'm trying to think of other examples. If you have an annuitized annuity, those payments are considered income. So any influx that is a regular payment to you is considered income.
Thank you.
Veterans payments as well.
Thank you. How does long-term care insurance factor in?
So long-term care insurance is often just considered another piece of income. So for example, some people say, well, I have $100 of a day of long-term care insurance, but it's not enough to cover the $550 a day bill at this facility. Well, then that $100 a day would go towards the facility's bill. That would be another piece of income, and Medicaid would pay the balance over and above the long-term care payments plus your income.
Thank you. Can you please explain pension money again?
Yeah, so pension is income. So if you are a single person, that will be another source of income that goes to the facility. If you have your spouse at home, then your spouse could potentially keep part of that pension based on how much money they already have and what other income you have.
Thank you. We have someone who tuned in 15 minutes late and they want to know if they have access to the recording. So we had started the recording by saying that this webinar, as well as other webinars, are recorded and will be uploaded on our website. So absolutely, you can refer to burnerlaw.com to view the full recording of this webinar. The next question is, when would a primary residence need to be sold if there is no spouse child?
Yeah, so generally speaking, and obviously, circumstances are different in all places, but if there is no exempt person to transfer the property to and no exempt person living in the property, then usually about 6 months after you, it's only exempt for that first 6 months or so that someone's in a facility. So you would want to sell it rather quickly and then probably do that promissory note planning with the proceeds if that person was not going to return home, because it would continue to be, even if you continue to get Medicaid, once it's no longer an exempt asset, Medicaid could put a lien on it. And so if you want to recoup the money from it and do that promissory note planning, it's usually in the best interest to sell and do the planning again, but that will vary from case to case.
Thank you. Next question. What happens to pooled income trust established for community Medicaid once you must go into a nursing home?
Yeah, good question. So the pooled income trust, and for those of you who don't know, very quickly, pooled income trust holds your excess income. Medicaid has an income limit when you're receiving community Medicaid in the home. You, unlike in a nursing home, you're allowed to keep a large portion of your income and you're allowed to use your income for your benefits so you can pay your other bills. That money is put into what's called a pooled income trust. That trust would have to be spent down and you would no longer contribute to the pooled income trust. So the ability to segregate income into that trust and continue to use it is lost when you go to a facility because all your income goes to the facility. So you would spend the pooled income trust money and then close the trust and you would no longer contribute to it.
Thank you. Next question. Are the spousal exemptions also referred to as spousal refusal?
So they're technically a little different. So spousal exemption are that there are certain that if you transfer assets to a spouse, or if a spouse is living in the residence, that asset is exempt or that transfer is exempt from having a penalty. Then the next level beyond that is, now that the spouse has all of these assets, they sign a spousal refusal, which is a document that says, I have these assets, but I need them for myself, and I am refusing to contribute towards the cost of care for my spouse. So the first part are the spousal exemptions and transfers, and then the spousal refusal. And depending on the county that you're in, certain counties very aggressively seek recovery from a spouse or from the estate of a spouse, and others do not. And so that's going to depend on the exact circumstance. But even in a spousal refusal situation, if the spouse has a very high level of assets and income, Medicaid can ask that spouse for contribution.
Thank you. Next question. Can a person make an exempt transfer of money into an existing special needs trust to a disabled adult without a 5-year look back?
So you can make a transfer to a trust for the benefit of a disabled person who is under 65 years of age. You know, in that case, it can be an existing trust, but it has to be for the sole benefit of the disabled person. And it's going to be, if you don't want any look back, that there is a payback to Medicaid at the death of the disabled person. So Medicaid applicant transfers to that beneficiary can live off of that money. But when that beneficiary dies, that trust must allow for there to be a payback to the program, to the Medicaid program.
Thank you. That looks like that's it for questions.
Great. I'm going to go into the last part that I wanted to discuss is the part that I hope that people are doing, which is how do you plan in advance? Because all these things I've told you, you know, the promissory note planning and the exempt transfers, they are available, but they're not always the best way. And the only way that we can be certain that assets will be protected is by protecting them ourselves in advance. And so one thing I recommend that everybody do, but certainly if you're worried about incapacity or disability down the line, is having a healthcare proxy and a living will. So a healthcare proxy saying who makes medical decisions for you if you can't make them for yourself, and a living will which says, you know, whether or not you want to be kept alive indefinitely if there is no reasonable expectation of recovery, and a good power of attorney. It's really important that you have a good power of attorney, because if you are at the point where you need a nursing home and these transfers have to be done, and especially those promissory note transfers, you might not be able to get that done on your own because of your physical inability or maybe cognitive ability at that time. So you have to make sure that whoever you're naming as power of attorney not just has a document, but has a document that gives them the power to do all of these things, to enter into promissory notes, to transfer your home, to create a trust, to put assets in a trust, to give assets to themselves. Remember my example, daughter took mom's assets and then did the promissory note. Well, we need the daughter to be able to gift to herself. So your power of attorney needs gifting authority. So important for Medicaid planning. And we have a new power of attorney as of June 13th, 2021 in New York State, where you will need to, if you've signed a document after June 13th of 2021, it will have to be on this new form. Documents that were signed before June 13th of 2021 are still valid, as long as they were valid at the time that they were signed. It's very important that your power of attorney include gifting. Before June 13th, it was done in this way. Your power of attorney document allowed for certain gift transactions. You would initial there. You would then have attached to the back of your power of attorney a document that was signed at the same time the power of attorney was signed. That is a statutory gifts rider, and it specifically allowed all the different powers, like the ones I talked about, allowing for creation of trusts, etc., that your agent can do. If you have a power of attorney that you signed before June 13th of 2021 and it does not have a gifts rider, your agent will not be able to do all of these things that I've just described. After June 13th, we still have the section where you initial that you want to allow gifting, but then the actual powers, those individual powers, have to go into what's called a modification section. We no longer have the rider on there. It's just one document. So having that good power of attorney that allows your agent to do everything I've described for you is incredibly important. And then of course there's advanced gifting, advanced transfers. Now, if you have your primary residence, many people are, two spouses, they often don't know which spouse is going to need care first. So sure, we have the ability to transfer to a spouse at the last minute, but what if one spouse needs Medicaid and then a year later, the other spouse needs Medicaid? We've never gotten that 5 years rolling. So what we usually recommend in many cases is that the spouses create trusts and get the property out of their name for Medicaid purposes, and then let 5 years go by so that it's outside of Medicaid's purview when we get to application time, regardless of which spouse or if it's both spouses. Now, an irrevocable trust is a trust that you and your spouse can't be the trustee of, but it can be your child, it could be your sibling, it could be whomever you want. It says that you receive all income. So if there, or I should say, it can say you receive all income. So if you want to put investments in there or a property that you rent out, you can receive that income, just knowing that that's income that might go to the facility later on. But while you're alive and well, you can receive that income. And you can't receive principal. So once we put assets into this trust, it's pretty much in that trust. In emergency situations, there are ways in which we can access it. But in general, when you put assets into this irrevocable trust, it goes into that trust, and then it's only upon your death and the death of your spouse that it will go to the next generation. But these are really great things. You can keep your STAR exemption. You can keep your veterans exemption. You are not going to have any, if you decide to sell the property, you still get your capital gains exemption for it being your primary residence, as long as it is in fact your primary residence. And so these trusts are really beneficial because you can also keep the power to change the trustee and the beneficiary. So if you don't like what they're doing or you think they're going rogue, you can remove them as both trustee and beneficiary. So that is also very helpful. So these are the types of things we like to do. This is why we encourage people to plan for the 5-year look back, plan in advance, and maybe not all of your assets are subject to that promissory note at the last minute. Maybe we've been able to protect a lot of them, and then some of them, you know, protect your house, protect your life insurance, and then we're just dealing with the cash when it gets closer to time of application. Any questions on any of that or anything else that we've discussed today? Looks like not. Okay, well, thank you everyone for joining. I hope this was a good overview of the chronic long-term care Medicaid program. As was clear, I think, from what I said at the beginning and also from what we discussed today, it can be incredibly complicated, and it's definitely something where you should receive personalized legal advice on what to do. So thank you and have a great day.